Good afternoon, guys, and today we continue our Legally Speaking series, seminars discussing immigration laws of the United States. My name is Alina Shevtsova. I'm an immigration attorney from Brooklyn, New York, and today we're going to be talking on asylum. Asylum, deadlines, procedure, what asylum is, and how to receive asylum in the United States. Asylum is a pardon, basically, that U.S. government, or I'm sorry, it's protection that the U.S. government gives to those who are afraid to return to their home countries. Asylum is an area of law that's regulated both by the United States law and a little bit by the immigration international laws. Why I say a little bit is because in the United States, the case law that's developed in the United States is prevailing, probably except for the definition of an asylee or refugee. The rest of the legal questions will be decided in the United States, at least according to the United States immigration law. So let's start with discussing who can receive asylum and what asylum is. Asylum is a status and is granted to those who, as I said, is unwilling or unable to return to their home country due to the fear of persecution based on national origin, race, political opinion, membership in a social group, or religious views. Those are the grounds that asylum can be granted. If somebody can establish the threshold, those are the grounds. It means that if somebody does not want to return to Mexico because his neighbor Pedro is going to or swore to kill him, this is not enough to receive asylum in the United States for the most part. Sometimes it is, but if this is just a fact pattern, let's say I'm afraid to go back to my home country because my neighbor has been giving me a hard time, and because of that I lost my job or I lost my house, this is not enough. If, let's say, the neighbor is also representative of the government, and somehow the neighbor does not like you because of your race or your religion, then it's a whole different story. Okay, so that's why excuse me, it's very important to know what asylum is and when somebody can receive it. So to receive asylum in the United States, you need to submit a form called I-589, and it can be found on the website www.uscis.gov. The form is free. There are instructions to the forms that every applicant must follow, because if they do not follow instructions, the form will be rejected. And it's crucial that the form will be submitted on time. Currently, there is a 1-year filing deadline. It means that a person who entered the United States has 1 year to apply for asylum. And we will discuss what happens if somebody does not comply with 1-year deadline, what can they do and what exceptions are. But basic and common rule is that somebody who entered the United States has to file the application for asylum within 1 year of entry. It can be, the entry, by the way, it's a physical entry. It can be legal, hopefully legal way, through visa or parole, or if somebody, let's say, they cross the border, it's still an entry for the purposes of asylum. Some people think that if they cross the border, they cannot file for asylum. This is not true. Anybody can file for asylum. Anybody who is physically in the United States, you have to be in the United States. If you're filing out of the United States, there is a totally different procedure for that, and the person will hold what's called refugee status, and we're not discussing that today. But we're talking about asylum, asylee status. So the form is free. It can be found on our governmental website, www.uscis.gov. Under the forms menu, there are instructions to it. A person has to follow instructions. They have to fill out every single field in the form. If you miss a field, when you're filling out the form, the government will reject it and will send the application back. It's very important. The form should be signed, preferably in blue ink. It is so the government sees that it is an original of the form. The form should be submitted together with copies of the form, a full copy of the person's passport from cover to cover, passport style photos, and evidence that prove asylum claim. What evidence? Very often I get a question. Well, how can I? What evidence I need to submit to prove my asylum claim? Well, I'll tell you that I don't know. I would not know it without talking to you and see what happened. I can just say that often and commonly, the evidence include, first of all, your personal story. You have to write it down. You have to be as detailed as possible, describing the events that happened to you. That's one thing. It's your story in the form of an affidavit. Then it can be photos. Let's say you're claiming that somebody beat you up. Do you have photos of that? Do you have medical records? Maybe some other people can testify to it. They also can submit affidavits or letters of support. Maybe the claim is that you lost your job. So maybe you have records of how you lost your job because of that. Maybe the government does not want you in the country and they're trying to push you out, force you out, or they're trying to scare you and they're doing different things to you. Like they attack your house, they set the house on fire or the car on fire, or they send different people to you and they threaten you, and you have recordings of those threats, maybe voicemails or text messages or emails, different things. Every single case is different. In every case, evidence will be different things. Sometimes the only evidence that the person has is their own story, and maybe if the person says that the person suffered some physical abuse or mental abuse, the person can go to a specialist in the United States, and that specialist can produce reports saying that upon evaluation, it's been, in that specialist's opinion, the person did suffer a certain persecution or certain physical or mental harm. So those are the evidence. I would not know in advance what those are without talking to the person and spending some time. Sometimes the person says, well, I don't have any evidence. I cannot present any evidence. But after we talk about everything that happened and we think together where we can find different proofs of different little things, almost always we can come up with something. It might not be a direct evidence. I would say almost never you're going to have, or a person is going to have a letter from the prosecutor, from the government saying that based on your political opinion, we're going to put you, in jail. They don't do that, right? They're going to say, well, it seems like you did not pay your taxes on time, and that's why you're going to go to jail for 10 years. But something like that. They forgot to mention in that statement that a year or a day prior to the statement, the person took part in a rally against the government or something like this. So, as I said, in every single case, the evidence, the proof will be different. The rule of evidence in immigration court is a little bit different than the rule of evidence in federal court in the United States. It means that the judge can actually consider different types of proofs, even what in a regular court would be considered a hearsay, and it's very important. So it means that an asylum applicant should not lose their chances to present and convince the court of the fact that they were persecuted or they have a reasonable fear of being persecuted just because they lack direct evidence. Sometimes, when does a person have to present evidence? Some people say that, my deadline is coming up. I don't have the letters from my witnesses, but I will be able to get them, let's say, in a month. That's fine. You can file your application, you can preserve your deadline and submit evidence at a later time. In fact, you should inform the government that that's what you intend to do. And if the government calls you for an interview and your evidence, you have not received that evidence, you can ask the government to delay your interview. It is not desirable to do that because under the laws of the United States, the person who files for asylum can receive employment authorization if his or her application is pending for 180 days after filing. And if the person is asking to delay the consideration of the case, that asylum clock for employment authorization stops. So that's why it's desirable to present all the evidence within that within the deadline before the interview and not cause any delays. But if you can't do anything about it and you do need more time, then you will have to ask the government for more time. The good thing that the clock should be restarted or should be started again, let's say, after you present the evidence, and delay is no longer there. Unfortunately, sometimes it's not the case, and the government reluctant to restart the clock or start it again. It pauses. It's not restarting again. So let's say if you submit your application and now your clock for employment authorization started, and 30 days later you called for an interview and you're not ready, and you say, I'm not ready, I need more time. Your clock stops. In 30 days, you present the evidence and the clock should be restarted. So the restarted clock will not be day 1, it should be day 31st. By the way, this timeline that I just gave is fantastic. It means that it's almost never going to happen nowadays in New York, at least. The reason is because there is a backlog of asylum cases, and people wait for an interview for years, literally, like over a year, or close to 2 years, or over 2 years. And only probably 1% of cases are called for an interview within 60 days from filing. This should be the standard, 60 days from filing. And they say that the government chooses the applications that will be called for an interview randomly, and computer does it. But probably only 1% of cases is within this time frame for 60 days, and the rest of the cases are sitting in line for years before they're called for an interview. What happens in the asylum interview? Well, asylum process in the United States, I should mention it, is a 2-tier process. First, you meet not a judge, but you meet an officer it's called asylum officer, a representative of the government, USCIS asylum officer, who talks to you and asks you different questions or interviews you. Those officers are trained to interview people who apply for asylum. They're trained to look for certain legal issues, for factual issues. Those training manuals that they use for training those people available online. It's not a secret how they're trained, at least nowadays. During the interview, asylum officer is going to take notes. I believe that nowadays also there is voice recordings and video recordings of the interview. Nowadays, those voice recordings are recoverable. So the person can get a copy of what he or she said during the interview. The interview may last from hour to several hours. I've heard that in Florida it can be up to 4 hours. A person can be questioned about everything that happened. Especially it is true if somebody is using an interpreter, because then everything is much slower. Also, what happens is that at the interview, it's your chance to explain everything. It's a very good chance to explain everything what happened to you. Basically, a person has to be as honest as possible. And if somebody does not remember something, they should tell it to the officer. Because the way the process of interview works, if the officer believes that you did not provide correct information and there are inconsistencies with your application will be denied. So let's say the office is asking you, well, tell me so-and-so, how many times you were bitten by the government? And you say, one person says, well, 3 times. Okay, and the interview goes on, and then the office is asking, well, you know, but in your application you actually said 2 times. And then you will have to explain under the law why you said 3 times. And it might be that you forgot to put it in your affidavit. It might be that you just freaked out and decided to make your claim better. But you will have to explain those inconsistencies. They're very important. The officer has to ask a person about inconsistencies, and the applicant has to explain to them, provide explanation about them. There is a federal law called Real ID Act, and under that law, if somebody cannot explain the inconsistencies, most likely the application will be denied if those inconsistencies are significant to the claim. That being said, it means that if there is a small discrepancies, or the person can provide explanation, let's say, you know what, I suffered a head trauma, I have a doctor's note, sometimes I can be confused, then it will be attached to the case, and at least there is an explanation of what's going on. Upon conclusion of the interview, most likely the applicant will not know the result. Very often, the practice is that the person has to come back for the result to the same place where the interview took place at a later date. Sometimes the decision is mailed. The usual practice, at least several years ago, was that if at the time of the interview the person is out of status, then the decision will be issued within 2 weeks of the interview. If the person was still in status, because you can file for asylum, even if you're still in valid status, let's say you're on F visa, you're a student, can you file for asylum? Yes, you can. Or you cross the border, you don't have any status, can you file for asylum? Yes, you can. So several years ago at least, it was that if you're still in status, most likely your decision will be mailed to you. And sometimes this mailing takes a long time. It can be several months before somebody gets their decision. It's nothing unusual, it's just that your case is not a priority, or the government needs to conduct further investigation. Sometimes the government sends a person something called notice of intent to deny. Basically, the government gives you a chance to explain all the inconsistencies that were discovered during the interview. And this is a person's chance to overcome the government's conclusion that the person lied, you lied at the interview. Well, what happens if the application gets denied? Does it mean that the person will be sent back to the country? Well, actually, the U.S. government gives the person a second chance. The person will be sent to immigration court, and the judge will de novo, meaning that the judge with a fresh eye is going to look at the application. This being said, does not mean that the judge will not have an information from the government as to what happened at the interview. So it means that the best practice would be to be prepared to explain, and the person probably would feel it from the interview how it went, as to inconsistencies or different problems that happened during the interview. Most common reason, though, for denial is not the factual inconsistencies. It is the 1-year deadline. The problem is many applicants, they do not comply with 1-year deadline, and they nevertheless file for asylum after the 1-year deadline. And a person still can receive asylum if they miss the 1-year deadline, but they will have to present an exception to the 1-year deadline filing rule, and that exception usually can be change of personal circumstances that cause the person now to be qualified for asylum, change of country conditions from the country in the country that the person is claiming asylum from. It can be something like, let's say somebody was in a legal status and was hesitant about applying for asylum, and He or she has been in the United States on an F visa for 2 years, and now status expired, and now they're filing. So that would fall under that exception as well. It's preferable that one works with an attorney every time when they have a problem of 1-year deadline, because now we enter a strictly legal area of interpretation whether or not a person can still qualify for relief even if they miss the deadline. So many times the USCIS offices do not want to, or they can't make this determination or make this call if the person qualified for an exception to 1-year deadline rule, and they refer the case to the judge. And that's why there are many referrals to immigration court. However, it doesn't mean that the officer does not have a power to make a decision. Sometimes when the case is very strong, they do, and they make those decisions, and they find that the person was excused from meeting the deadline. So let's say you were referred to court. What happens next? Well, first of all, first hearing that will happen in court is called master hearing. It's just a small court, what we call a preliminary hearing. It's going to be the first time the person meets the judge, and the judge will just ask the person what relief he or she is going to apply for, if he wants or she wants to rely on previously filed application, or there will be amendments, and will set deadlines. Now, it's very important to know one little thing about this court situation. If the case is transferred to court within the 180 days from the time the person filed for asylum, and during that first master hearing, the court offers what's called an expedited date for the hearing, the person will have to agree to take it, because otherwise he or she will lose chance for employment authorization. Because if the person says, well, judge, I'm not ready to go for my individual hearing in 3 weeks, then the court says, okay, no problem, I'm gonna give you a day 3 years from now. Is it enough? Yes, enough. But at the same time, the clock for employment authorization stops, and it will not restart it unless the person appears for the individual hearing, meaning 3 years later. So that's a very important thing that some people do not know, and they think that they will have sufficient time, and then they get stuck in the situation when they cannot work legally. At the same time, they don't want to accept work, or they don't want to work illegally, and it's a stressful situation, because for years they have to live in the country, and they can't legally work, and then they're afraid to tell in court or say in court that they did work illegally. They don't know what to do. So that's why it's important to be represented in immigration court. Things that can happen. After the master hearing, usually the judge sets a date for individual hearing. What is it? Well, it's a mini trial, pretty much. During that hearing, a person will be questioned by his or her lawyer, if he has one, if the person has a lawyer, prosecutor, and the judge. The judge can and will ask questions in immigration court. It's not a regular
Yes, in your prison for like a week,
where the judge will not be able to question the person, and that's very important to know. If everything goes well, and most times it should go well if you prepared well and you know what you're doing, and you don't have illegal issues, and we will cover them, what those can be. The judge will issue an oral decision, and the government can appeal it. That's very important. Usually the judge asks the government, would you like to waive the appeal? And most of the times, the government, if they believe that there was a compelling case presented, the government will say, yes, we'll waive the appeal, or both parties waive the appeal. If the government does not waive the appeal, then the case might last for many years, because the next step would be to fight the case in the Board of Immigration Appeals. So that's very important to win the case when you first appear in front of the judge during the individual hearing. During that hearing, by the way, a person can present except for testimony of the witnesses. If those are live witnesses, that's perfect. Witnesses may appear from the court's permission telephonically. It can be different experts as well. So it's a mini trial. The person has to be prepared for that. If person is granted asylum status, he or she from now on will be an asylee. That person will be able to get employment authorization, of course, and in 1 year the person will be able to apply for green card and become a permanent resident. That's important. What happens if that person's family is overseas? Well, if the person was married at the time the application was granted and included his family members and children under 21, family members, I mean the spouse and children under 21, who were under 21 at the time of filing for asylum, those people can come to the United States within relatively short time, 4 to 6 months, and join the person who won asylum case. That's very, very important. We also spoke about, I just mentioned the fact that sometimes a person is precluded from filing for asylum. Why is that? Well, most of the times it would be a criminal conviction, aside from the pure political offense. And it should be pretty serious criminal conviction, because minor convictions still probably will allow a person to apply for asylum, but serious convictions will not. Amongst them, something called aggravated felony. It's an immigration term of art. A crime of violence, let's say somebody assaulted somebody, they probably will not be able, and were convicted and spent time in jail. And it does not matter where that crime took place and where the person was convicted. They will not be able to file for asylum. So basically the government says that we do not want people who are not good to take advantage. But as I said, every crime, every conviction is different. A legal analysis is needed to determine whether or not a particular conviction will be a problem. What else can be a problem? Well, it's a fraudulent asylum or false information on asylum application. Just there was a recent decision, I believe, by federal court, where the court decided that because a person filed asylum claim and admitted to have some untrue facts in that claim, the person was precluded from filing, from winning asylum. Even though that it could have been true later, what happened basically, that the person first says that she was a part and was supporting an organization of certain organization. After the person filed her claim, the government, the U.S. government, included that organization into the list of terrorist organizations. Okay, so before her case was decided by immigration judge, she decided to change her story and say that her first lawyer who filed the application lied. She was never supporting that particular organization. The case went on appeal, for an appeal. By the time the case was decided by an appellate division, the U.S. government deleted that organization from the list of terrorist organizations. And now the person got stuck, pretty much. If she would consistently say that she was supporting that organization, she would now have asylum. But because she decided to change her story and go with a different line of story, and now nobody believed her, she lost her chance. So it's very important to be honest, and very important not to include any false information, false facts, because if they get discovered, the penalty is very harsh. Somebody who is recognized by the government to file a false asylum claim is permanently precluded from any type of relief in the United States, immigration relief. So most of the times when people come to me and they say, I went to another lawyer and the lawyer told me that I qualify for cancellation of removal. But you see, for that, I need to be in front of immigration judge. And that's why that lawyer offered me to first file for asylum, because my asylum claim will be denied and I will be put in immigration proceedings relatively quickly. Well, that's fantastic, but it also means you're probably going to be filing false asylum claim, which is not a good idea. So if somebody wants to appear in front of immigration judge, filing a false asylum claim just to be referred to immigration court is a very bad idea. So that's the basics of a mechanism of filing for asylum. Of course, this topic is huge. It's impossible to cover all the little things and all the recent cases, what happens, every story is different. But the main point that people should remember is that 1-year deadline, providing true information, including every family member. Because if you don't say that you have a child when you file for asylum, and after you received it, you say, well, by the way, I have 5 children in Nigeria. Well, guess what? That's gonna be difficult to bring them over here afterwards. And preparing for the case, you can't expect the judge or the USCIS officer to issue a positive decision if you just say that, well, I've been persecuted in my country because I'm Muslim. Well, okay, what specific facts you have? Under the Real ID Act, the person has to provide specifics as to what happened to them. If they don't do that, the government cannot possibly make a decision on the claim, and of course the claim will be denied. One solution to the 1-year deadline, if let's say the government will recognize that a person could have been qualified for asylum or something similar, but they missed the 1-year deadline and they do not fall under any of the exceptions, there is something called withholding or removal. Withholding or removal is a status that's actually granted to somebody who has an order of removal against them. So when and if the person calls 800 immigration system, they will hear the message saying that the judge ordered removal, and only the person knows that it's actually withholding or removal that's specified in the order by the immigration judge. It's a special status that is given to somebody who was not able to meet 1-year deadline or otherwise qualify for asylum, but actually the threshold for withholding or removal is higher than for asylum. And that person may stay in the United States and may work, but cannot travel internationally and cannot apply for green card or permanent residency. This is the 2 biggest distinctions between asylum status and withholding or removal. Asylum status allows a person to adjust his or her status to one of a permanent resident after they've been in asylum status for a year in the United States. And withholding does not. So that's important to know. Before some people, they appear pro se and they say, okay, I will agree to it. I'm not going to fight the government for my 1-year deadline. And then they're like, I would like to travel somewhere. I'd like to go to Canada, and they find out that they cannot. So that's important to know that there is a distinction. How one files for withholding or removal? Well, it's actually the same form. I-589 is the same form is used for asylum, withholding or removal, and for relief under Convention Against Torture. All that stuff is filed in the same form. That's probably the basics and the basic information about asylum and deadlines. And if you guys have any questions right now, I'll be happy to answer them. All right, I see that I have a question from Google Plus people asking about how long does it take to receive asylum in the United States. Well, it actually varies. Maybe 8 years ago, it was relatively short time because there were not as many cases and people would be called for an interview much sooner than nowadays. But typically, a person should count on being in the stage of waiting for several years, especially if they're referred to immigration court. Right now, the wait time in immigration court in New York is about 3 years before a person can see a judge for individual hearing, plus 2 years for an interview, so the process can take up to 5 years, even more if it goes on appeal. So it's a very lengthy process, and a person who is considering filing for asylum has to be prepared that they might not know the final decision on the application for a very, very long time. Okay, how much does it cost to file for asylum? Well, it doesn't cost anything if you're doing it yourself. The forms are free, submissions are free. The immigration court or the asylum office does not charge any money for it. The cost that you might have, they usually relate to an attorney's fees, and every lawyer charges differently. Sometimes I see ads online saying filing for asylum for $1,500. I really would like to know what they do for $1,500. Why? Is because when an attorney working on asylum case, attorney has to sit with an applicant and go through everything. Attorney has to prepare an applicant for the interview, go with them for an interview, be basically available to the person 24/7 pretty much at the filing stage. So I don't think an average attorney that I know would charge $1,500. It's probably going to be several $1,000s. Plus, a person, if they would like to use experts during asylum procedures, they will have to pay for that too, and it can be costly. There are organizations that do provide free legal help. One of them is Catholic Charities. There are lines to get there, but if you do, you're a lucky one because they will give you an attorney for free. So let's say somebody cannot afford to pay this money, and probably most people can't. They can find free legal help if they go to online. They can use public libraries to go online and see for free legal help. Sometimes legal aid will take people. Right now I know that at least in New York, legal aid received funds to work in the immigration area. Local bar association is a good source for pro bono attorneys, lawyers who will basically provide services for free. So those are good leads if somebody really needs to find a free immigration attorney to help. There are also consultants and organizations that provide free legal help through immigration consultants. The law does allow non-lawyers to help, to assist clients in the immigration area. But those people, they have to work for special organizations that's accredited, and they have to work under supervision of lawyers. So that's important to know. There is a lot of abuse in the immigration area, like people who are not lawyers trying to solicit clients, and they promise us great results that they cannot deliver. So if you are looking for an immigration attorney, you really, and you don't have to be ashamed to ask the person who is talking to you, are you a lawyer? Do you have a license in the United States? That's a normal question, and your lawyer will say yes. And by the way, in most of the states, I believe, you can look up a person and see if they're in fact a licensed attorney in the United States. All right, I am available to answer further questions if they're submitted through my website, www.shautsova.com. It is SHAUTSOVA.com, and I will be happy to answer questions from my website. You guys, thank you for joining us today, and have a great the rest of the day.